Hello, good morning. 11:30, 11:29, almost 11:30 a.m. Eastern Time. Good morning, good morning. We have great news to report. Yes, join me in this live session. I know it's kind of too early, but we have great news to report. So when we have great news, it doesn't matter what time we report it, okay? Because we gotta save somebody before the end of this year. We are here to report great news. If you're here, say hi in the comment. We're going to talk about waivers, fraud, willful misrepresentation, how to present your case so that you can get it right. Okay? Let me know in the comment, where are you? What you're doing? Yes, and how can you win a waiver, so to speak? Okay? Uh, yes, so let me know in the comments, where are you, before we get started. Yeah, I'm trying to pull up all the information so we can get it right and explain to you this topic, most important topic. Okay. Yes, Tom Ngwanda, Baltimore. Oh, you right here in Baltimore. How are you? This is the first time, right? Or not the first time. How are you? How are you feeling? Early this morning, we got 8 people in the house. Please go ahead and like and share. We're gonna talk about this most important topic, waiver. I've talked about it a lot, but when it comes to willful misrepresentation or fraud, and fraud, because it's two different topics. But if you're convicted or charged with willful misrepresentation, um, it does not mean necessarily fraud. But if you're charged with fraud, then willful misrepresentation is included. So, and in order to win, you have to have a waiver granted to you. And in order for the waiver to be granted to you, you have to have a qualifying relative. It has to be a spouse or a parent, lawful permanent resident or U.S. citizen, and you have to be able to show extreme hardship to that qualifying relative. So we're going to talk about it. Let me share the screen with you. This was approved within 2 months. Let me share the screen so you will see for real that, because we have to bring proof, right? We gotta bring proof, okay? When we talk about the subject, we need proof. So you can see here, right? I-601 application for waiver of grounds of inadmissibility was filed on September 11, 2023, approved on November 28, 2023. So 2 months and pretty much 2 months and 1 week, right? Or 2 weeks. Pretty much 2 months anyway, so to speak. And you can see my office address here, Connecticut Avenue, approval notice. This waiver is approved in connection to a green card that was filed. Just know that for the backstory, the green card was filed in 2021, September of 2021, 2 years ago. And the reason it's taking too long is because the person in question was still in removal proceedings. We had to terminate first removal proceeding, then go back again to USCIS with this waiver application and other stuff. So pretty much when this waiver is approved, it means that very soon this person is going to get their green card. Okay, that's it. This is the holder to a green card. Once they receive the examination, the medical exam, that's it. Game is over. This person is going to get a green card pretty much 23 years later. Okay, 2 decades later, and this is based on marriage. First marriage was denied, ended in divorce. Second marriage was um, too much going on because of that misrepresentation. That's why I keep saying that the most bad thing you can do to your immigration case is to lie. Even a simple lie, right? It can cost you a lot of delays. And mind you, if this waiver is not granted, then the green card is going to be denied. So then you have to make sure that the waiver is granted. Let me stop right here and take some questions first. Stop sharing. Anybody has a question? If you have a hi, can you get a waiver against an order of removal? What do you mean get a waiver against an order of removal? So when a person has been ordered removed, you don't get a waiver for that. Basically, what happened is, depending if you are outside or inside of the US, if you're inside of the US and something becomes available, another type, like let's say something, a relief becomes available, what's going to have to do is go back to them and ask them to reopen the case, and so that you can adjust status. That's why we talk about those joint motion to reopen. You ask ICE to join you, because once order has been entered, then it's like case game is over, right? So then you have to go back to them, joint motion to reopen, and try to reopen your case. If you have an approved petition like I-130, then go and try to reopen the case. And if the case gets reopened, then you can terminate removal and go back again to USCIS and try to adjust status. So I'm not sure what you're talking about against waiver against an order of removal. So if a person has been ordered removed, it means that they pretty much use all their venue, and then they ended it with the order of removal. So you cannot waive that, but you can either appeal it. But if you don't win on appeal, the only thing you can do is wait. When you have something available, another remedy available, like I-130 approved, then go back and try to reopen it. So basically what you're trying to say, that you were not there. Inside the DNS, but you were not there when they order you removed. Well, if you are not present when they order you removed, first we have to know why you failed to appear. So if you failed to appear, right, notice because the notice was not, you were not there, right, because you failed to appear. First, we have to know why you failed to appear. Because if a person failed to appear, they have like a 5 years ban, so to speak, right? Of course, they're gonna have a waiver. They're gonna need a waiver later on when they're trying to adjust status. But the underlying cause is why you failed to appear. Did you fail to appear because you did not receive a notice to appear, or why did you fail to appear? If you don't have good cause as to why you failed to appear, you still have a ban, right, from adjusting status. And when the time comes to adjust status, the same procedure. You're gonna have to try to reopen the case first. Once you reopen your case, then depending on I-130, what type of I-130 that was approved, then go back to USCIS. But there's no such a waiver as to waive immigration order. It's just that basically, depending on the reason you failed to appear, if there is good cause, then you have time to reopen your case. If there's no good cause, then you're banned, first of all, for 5 years to adjust status. And when the time to adjust status comes, again, same procedure, you have to go back. Tom wants that you need to schedule consultation, because, you know, if you are in removal and you're trying to do things, it's better to have some type of guidance. Treasure, I need explanation for a church sponsor. No, Treasure. We have a lot of videos about when a church can sponsor somebody. Yeah, you're gonna have to go back to my videos and watch them, or you can schedule a consultation so we can explain to you. But we We don't do explanation like that. So we make videos. If somebody feel qualified, then they schedule a consultation. Then we see the requirement if they are qualified. But when you talk about I need explanation, it's like it's almost like you're asking me to teach about it, which I already did. So it's on my video. It's on my USCIS YouTube channel. So if you go to no USCIS, sorry, it's on my YouTube channel. If you go to to my YouTube channel, I have a lot of videos on church sponsorship. Just go ahead and watch them. If you have questions, that's when you come with your questions here on live, or you schedule a paid consultation. All the consultation links are in the description box below. Let me just put it here first of all, so that if somebody needs a consultation, they can schedule it. Let me put a consultation link here in the chat. Okay. Okay, Trump was arresting people in court. That's why you were scared to. Yeah, so basically, it's on you, right? And there's no waiver for that. So as I was saying, what you're gonna have to do if you have something like I-130 approved, it has to be family-based, qualifying, like immediate relative, either spouse or a child who's a U.S. citizen over the age of 21. If you have that type of petition and you want to go back to court to reopen your case, that's when we can try to like pretty much beg ICE to reopen your case. And at that point, that's when you're going to need those waiver for failure to appear, because you barred for 5 years to adjust status. So Tom Mwanza, I have my consultation link right there. You really need a consultation if you have an I-130 approved. You're gonna need guidance to do it the right way, okay? and you're in Baltimore, so I am here in DC. What a best place to be. Treasure. Okay, you just saw my channel and you're gonna follow me. That's good. Great. That's good. Yes, that's what I was saying. You can go back and watch those videos. We talked about church sponsorship, and if you feel like you qualify, then schedule a consultation. We're gonna talk to you about it. It's a paid consultation. Okay. Elena, that's good to hear. Yes, I'm glad you're here. Please like as well, and please share. Marcatori, your case is still pending motion to reopen. With Marcatori, I think I've talked to you before, right? Your case is still pending BIA. You just have to wait. And last time too, I believe last month or 2 months ago, I talked about how can somebody expedite their case with BIA. And if you go on EOR, you can see how you can expedite your case if you have a compelling reason. Because BIA, they don't really take those expedite requests anyway. If the case just stay there, you just wait until, when you're going to do it. But when they're going to do it, you don't know. But if you have a compelling reason and you want to expedite your case, you can try. But what's going to happen is they don't even tell you whether they agree with the expedite request or not. If they feel like the reason is compelling, then they're going to decide on your case. If not, then it's just going to sit there until the day they're going to decide. So 1 year case, I've seen case pending with BIA from 2 months to 4 years. So 1 year, it's just wait. Really, there's nothing much you can do. Just wait. If you like, maybe before the end of this month, they can, because sometimes at the end of the year, they try to process as much cases as they can, especially those motions to reopen. Tom wants a yes, you schedule consult. Yes, that's the best decision you will ever make, because you're gonna get really guidance on what exactly you can do. as far as your case is concerned and adjustment of status. Okay, and I'm here in this area. My consultation is pretty much on Zoom, but when you decide to go with me, then we can meet in person and discuss your options. Okay, who else has a question? Anybody else has a question? Please go ahead and like and share. Please go ahead and like and share. Let me discuss again this willful misrepresentation. Okay, I always tell people, please, if you're filing an application, either with for your visa, if the person is abroad or inside of the United States, there's no reason to lie on the application. Just state the facts the way they are. If you have children, put your children. If you have if you've been married before, just mention it. If you've been in court before, just mention it. Because what's going to happen if USCIS find out that you failed to mention, failure to disclose can be construed as misrepresentation. That's why people green card get denied. So that's how people get denied. So it's something to really think about when somebody's filing those applications. How to know the location of your case? There's only one location for BIA case. It's Virginia. There's only one location for case when cases are with BIA. It's only Virginia. So I don't know what you're talking about how to know the location. Yeah. McIntyre, your case is just about patience, pretty much. They already did everything they were supposed to do. The motion's pending with BIA. It's only patience. The only thing you can do is just have patience. That's it. So that's the only thing pretty much you can do. Another thing you can do is try to file a motion to expedite if you have a compelling reason. If you do not have a compelling reason, it's pretty much like a waste of money and time. So yeah, mandatory, just wait. Your time will come. Okay. We got 12 people in the house. Please go ahead and share and like. In the meantime, let me share my screen again one more time to discuss misrepresentation so that if somebody needs a waiver, we can try to waive it, okay? Share. Okay. Adjudication of fraud and willful misrepresentation waivers, okay? First of all, if inadmissible, USCIS will let you know. Under Trump, they will not even let you know. They're just going to deny it. Then you start over. But under Biden, they'll send you a request for evidence or intent to deny. Then they'll let you know for sure that you have misrepresented facts before, and they give you an opportunity to file for a waiver. Okay. The applicant must meet the following requirement before a waiver can be granted. The applicant must show that denial of admission to or removal from the United States will result in extreme hardship to the qualifying relative, you see, except for applicant for VAWA. They don't need a qualifying relative because the waiver and the extreme hardship is to themselves, okay? And then the applicants must show that a favorable exercise of discretion is warranted, okay? So it's not just filing for a waiver. It's pretty much meeting, first of all, the requirement for hardship, extreme hardship. Then showing that they need a favorable discretion, because it's a matter of discretion too, even if when a person meets those requirements, okay? So that's why you really need somebody who's qualified to write those briefs, to write that explanation, that argument for you, so that your waiver can be granted. And in some instances too, we have tried at least to defeat those charges by saying, for example, for willful misrepresentation, we have tried to say that the misrepresentation question wasn't material. For fraud, we have tried to say that there's no intention no intent to defraud somebody, that's when somebody does not have a qualifying relative or there's no really extreme hardship. We're going to try to pretty much argue that this is not willful misrepresentation because one element is missing, or this is not fraud because one element is missing. You see, it has a qualifying relative, has to be U.S. citizen, lawful parent or spouse, lawful permanent resident parent or spouse, or fiance. Okay. For K1 or K2 visa applicant only, that's when the fiance thing is get involved. Okay. U.S. citizen or lawful permanent children are not qualified for the waiver of fraud. And then the VAWA self-petitioner does not need a qualifying relative. Okay. And how they make extreme hardship decision, well, it's whether they look at a lot of things, right? The totality of circumstances. And then again, it's a matter of discretion. Okay. So, and then they go ahead and explain to you a lot of things. Let me stop right here and take some questions. Okay, do we have questions? Oh my gosh, it's getting the lightning is, let me put the lightning again. Okay. Yes, so anybody else has a question? Maka Traore, I don't understand your question anymore. Because what happened when I talked to you before, your case was pending with BIA because that's where they file a motion to reopen, and it's still pending, and you just have to wait. Okay. And now you're asking how long. Nobody knows. Nobody knows how long it takes for prosecutorial discretion in New York. Nobody can tell you like it's going to take 2 years because your case is with BIA. BIA takes from 2 months to 4 years. It's just, you need patience. You're just going to go crazy for no reasons. Nobody's going to tell you that it's going to take only 2 years, 2 months or 3 months. That's a lie because they don't know. That's why it's called prosecutorial discretion, because it's at their discretion to decide when to decide. You know what I mean? So, Tom Ngwanda, my consultation is on Zoom, okay? So you don't need to come to the office for the consultation. The initial consultation is on Zoom. We're gonna talk on Zoom. After that, if you agree to get me, to retain me as a lawyer, that's when you come to the office with the retainer fees. There's no free parking. You're gonna have to take the train. It's better actually to take the train, but there's paid parking. Yeah, the parking is like for all days like $22, for half days like $16. Yeah, but my consultation, it's on Zoom like that. We're gonna talk with you just like this, okay? Yeah, market tower. Yeah, you just need patience, to be honest with you. That's the only thing you need. Otherwise, you're just gonna get crazy. When a case goes to BIA, nobody has control over that. Okay, it's gonna take the time it's gonna take. But if you need to expedite, you can try, right? If you have a compelling reasons, and you talk to your lawyer about expedite request and give your reason, and then she's gonna try. But BIA, they don't really care about those expedite. They just decide when they decide. Unless somebody's dying, like they have proof of cancer or something, that's when they can expedite a case. Otherwise, just forget it. So just have patience. Your time will come, okay? And nobody's going to tell you how long it's going to take. They're going to lie to you because nobody knows. Okay? Yeah, I feel you, but just have patience. That's it. That's all I can tell you. Tom Monza. Okay, thanks, very helpful. You're welcome. We got 12 people in the house. Please go ahead and share. Please go ahead and like. I know the lightning is like sometimes it gets dark, sometimes it gets okay. Yeah. I'm trying to put the lightning here. Okay. USCIS Elena Daji. USCIS deny your 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 citizenship because you work in Rhode Island and your husband live in New York. Okay. So when USCIS denied the citizenship, you have to file what they call N-336, request for hearing. And when you request a hearing, they give you a date. That's when you're gonna go there with evidence to pretty much defend yourself as to why you work in Ireland. It looks like you live in Rhode Island and your husband live in New York City. So that's when you're gonna show all this evidence. The reason I do that because I live there, my husband live in because I work there or something around those lines. But if it's already denied, you have to just apply for the N-336 within 30 days or 33 days. They give you in the denial letter, they will give you the time frame on when to apply. And then you request a hearing. That's when you're going to have the opportunity to defend yourself. So, and at that point, if it doesn't work, some people go to federal court, depending really on the evidence that you have. If you have strong evidence, it might work. Or some people just wait until next time and file again. It's just up to you. Elena Daje, if you still have that time frame of 33 days, I'll strongly suggest that you schedule a consultation with me, okay? Yeah, if you're still within that time frame of filing the form N-336, request for hearing on a denial of naturalization, yes, schedule a consultation. This is the consultation link, okay? It's right there. Yeah, it's just depend on what evidence you have, because when you schedule that hearing, that's when you have the opportunity to defend yourself, so to speak. Okay. Anybody else has a question? Oh my God, this lightning today is not helping. It's like, anyway, as long as you can see me, right? Anybody else has a question? By the way, please go ahead and like and share. This is a great news we have. In 2 months, a waiver approved. Wow. You're welcome, Elena Dagby. You're welcome. 14 people in the house. Please go ahead and like and share. Anybody else has a question? Please put it in the comment. Yeah, if you have a question, please put it in the comment. Yes, please put it in the comments so we can answer your question. But if you need a consultation, just schedule it. Really, all the consultation links are in the description box below. Okay, let's see who else has a question. Okay, I guess all the questions have been answered. Okay. Yeah, if you need a consultation, my friend, please schedule it by using the consultation links in the description box below. If you have a question, just put it in the comments so we can answer it before we end our live session. By the way, please like and share. I'm so sorry for the lightning. It goes in and out. I'm not sure why, but the message has been given. When it comes to misrepresentation, you have to have a qualifying relative and be able to show extreme hardship. And really, you need a lawyer for that, because this the way we write is different from the way you're gonna write it. That's why you need a lawyer for that. Beni Akiben. Processing due date was extended by 5 months on my profile in USCIS, and I don't know what happened. It's just delay. That's it. Nothing happened. It's just that USCIS, they're just delaying. It's just like, you know how USCIS is, pretty much late. They're always late. Just wait. Your time will come. If the time has passed, you can file an inquiry online to inquire about your case. If the processing time has lapsed, the way you know, if you go on uscis.gov processing time, you put your application and the date. It's going to show you exactly when to follow up with them online. Yeah, that's it. Other than that, it's just delay, normal delay. No, I wouldn't know why. Elena Dache, I wouldn't know why, because usually when you have a 2 years, uh, when when you remove the condition, then it becomes a 10 years, right? So I'm not sure why they'll do 8 years instead of 10 years. So I guess they haven't given her the actual green card. That's why they're just extending with those letters. To be honest, I don't know for sure. Yeah, I can't really tell you because I don't know why they would do that. Usually when somebody has a 2 years conditional and then they remove condition, they have to give them a 10 years green card, not 8 years. So I'm not sure what's happening right there. I'm not quite sure. Yes, so this is the website where you can Beni Akbiden. This is the website right there where you can go and find out about processing times. Put your application, the type of application, the date you file, then it's gonna tell you exactly when you can follow up with them online. Yeah. Anyway, thank you very much for showing up. Please like, please share. If you have another question, could just drop it in the comments. If you need a consultation, all the consultation links are in the description box below. Thank you very much. Until next time, bye-bye. You're welcome, Benny. You're welcome. Bye-bye.